campus, the commercial law students were writing a face-to-face test that I had to supervise. And yeah, just when one of your classmates asked me if there's class, I remembered for the first time I was supposed to teach you. So my absolute apologies about that. Let's see how far we get tonight with Unit 14. Unit 14 is quite a long unit. There's a lot of information in there. Just give me a second. Yeah, there's a lot of information in there. It's important and it can be a little bit complex. So I would rather not rush to finish. I'll see how far we get tonight. If it is necessary, I'd rather stop after about an hour and a half gets a bit long. Your brain starts getting tired. And then maybe work in another class on Saturday morning. Late morning. It will have to be late morning because I have a face-to-face test on campus at 9. But let's see. Let me share my screen.
Ma'am, sorry, I wanted to ask, aren't we continuing with Unit 13? Because I think we only started, or did I miss a class?
Okay, thumbs up, everybody. Or somebody at least. If you can see my screen. Just confirm that fully. I need to switch my own sound on so that I can hear. Okay, so Unit 14, capital maintenance. What is this all about? So, you know by now that a company raises capital by selling shares. You also know that when companies started about 200 years ago, the whole concept behind a company was that it's just, sorry, there's somebody and I don't know, interrupted myself now. I don't know why people send WhatsApps during class time. I've just gotten a WhatsApp on the group asking, are we done with Unit 13? Of course we're done with Unit 13. It was included in your test. Please, it's very rude to WhatsApp on the group while everybody is supposed to be in the class. Having said that, it takes money to make money. Concept of a company arose originally because some entrepreneur had a business idea and they wanted to start a business based on this idea. In order to get money, they would sell shares in the company in order to raise the capital to start the business. You also know by now, I don't need to even explain this anymore, that a company is a juristic person. So the shareholders are not liable for the debts of the company. Now, of course, any person doing business with a company is aware of the fact that if they enter into an agreement with this company and the company owes them money, there is a risk that they might not be paid and that the shareholders walk away practically scot-free. They might lose whatever they originally paid for their shares, but otherwise the creditors can't hold them liable. So this is the historic background behind the concept of capital maintenance. So way back in 1887, in an important company law case, namely Trevor versus Whitworth. Don't need to remember the name of the case. 1887, that's many, many years ago. Lord Watson in Trevor versus Whitworth said the following in his judgment, namely that the paid-up capital of a company may be diminished or lost in the course of the company's trading. That is a result that no legislation can prevent. But persons who deal with and give credit to a limited company naturally rely on the fact that the company is trading with a certain amount of capital already paid, as well as upon the responsibility of its members for the capital remaining at call. And they are entitled to assume that no part of the capital which has been paid into the coffers of the company has subsequently been paid out, except in the legitimate course of business. Big English, fancy English words there. You don't have to remember these fancy English words that Lord Whitworth said. In essence, what it comes down, wait, let me go back to this slide first. What it boils down to, the historic background of the concept of capital maintenance, is that creditors, when they deal with a company, they look at the capital of the company to assess whether they have a reasonable chance of their debts being paid, them getting their money back. Now, business is business. Sometimes some of this capital might be lost in the course of trading. That can't be prevented. You can't make a law to prevent that. But, and this is the concept of capital maintenance, the feeling was very strong at the time that the capital, the shareholders contributed the capital. But once they contributed the capital belonged to the company, and under no circumstances was the capital allowed to be returned to the shareholders. Once you've paid for your shares, you can't claim that money back. If you put money into a company and you want it back, you're not a shareholder, you are a creditor. So based on this underlying principle, at common law at the time, certain rules of capital maintenance were formulated, and these were very strictly applied. Capital of a company had to be protected for the sake of the creditors and may not be returned to the shareholders. The rule supporting this principle was that, firstly, a company may not buy back its own shares. A company may not pay dividend out of capital, and a company may not issue par value shares at a discount. So those are the three common law rules. In addition to these common law rules, in, I think, the 1945 Company Law Act, can't quite remember which act it was, that's not important, but a further statutory rule was made, So in addition to these three common law rules, there is also a statutory rule which states that a company may not give any financial assistance for the purchase of its own shares. You need to know those three rules. You need to know the statutory provision. But of course, times changed and conditions have changed, and the manner in which companies do business changed over the years. We all realize by now, I've spoken about this already, that a company's business is no longer really at start-up phase financed out of share capital. Entrepreneur that wants to start a business will register a company for the sake of the protection of the juristic person. But they won't try to finance their money, their company, their business originally out of selling shares. They go to a bank and they borrow money. So as times changed, it became apparent that these strict rules of capital maintenance were actually becoming more detrimental to business than actually serving an actual real purpose. Another issue that arose in the course of time is, yes, these strict capital maintenance rules protect your creditors, but what about your shareholders? Remember, division of corporate functions, two organs of a company, directors, shareholders. Shareholders are your owners of the company. The directors manage the company. Just give me a second. So the shareholders also deserve a measure of protection, and not only creditors, whereas these strict capital maintenance rules focused only on the protection of your creditors. So in the course of time, and primarily in our latest Companies Act, the 2004 Companies Act, that's the one that we study, made some very drastic changes to these capital maintenance rules. So what you've got to understand is that there were these common law rules, and I can ask you in the exam to list these common law rules, but in essence, they don't actually apply anymore. In 2025, they have all been changed. So the first one, our first capital maintenance rule was, go back to that slide, a company may not buy back its own shares. 2004 Act, Section 89, amended this, didn't amend, it actually did away with the common law rules. Section 89 states that a company may buy back its own shares, provided that certain requirements have been met. These are the requirements. I'm going to go through them now. I need to, before I start going through the requirements, just warn you, this is one of these instances. You'll remember in the beginning of the semester, when we did the different types of companies, I actually told you always to be aware of what type of company I am referring to in a case study. Because in some instances, your answer, the correct answer to a question, a case study question, will depend It will differ depending what type of company we're dealing with. This is one of those instances. When you answer a question based on capital maintenance on a company buying back its own shares, don't just blindly write down all these requirements. In your answer, be specific. If you're not specific, you will not get maximum marks. Okay, I'll get back to that. I'll clarify that again once I've gone through these requirements. So the first requirement is that the articles, the constitution of the company, must allow a company to buy back its own shares. If there's no provision in the articles for a company to buy back its own shares, the articles must be amended by way of a special resolution. Companies registered before the commencement of the 2004 Act will not have a provision in their constitution to allow them to buy back their own shares, because before 2004 it was illegal. Companies registered after that will probably already have included this in their constitution, but if it's not in the constitution, if there's no provision in the constitution that a company may buy back its own shares, there must be a general meeting of shareholders where a resolution must be adopted by way of special resolution to amend the articles. Then, if it's allowed, if it's permitted in the articles, to start the process, there must be a second special resolution. So we're talking of two different special resolutions here. One changing the articles, and then a special resolution to approve the transaction. Now, the special resolution to approve the transaction can be one of two types, so to speak. It can either be a general approval, which will then be valid until the next annual general meeting, or it can be a specific approval for a particular acquisition. What is the difference between these? A general approval would be if a company wishes to buy back a certain number or a certain percentage of a particular class of shares. So let's say it has Class A shares, ordinary shares, and preference shares, but because of preferential dividends being paid to the preference shareholders, they actually want to reduce the amount of preference shareholders to increase the dividend potential of the ordinary shares. So they decide to buy back 50% of the preference shares. So it's 50% of the preference shares at a particular price. It's not specifically targeted at Daniela, Roche, Evelina, and Ayla. It's targeted at whoever preference shareholders want to take up this offer to sell their shares back. That is a general approval. A specific approval, on the other hand, a specific approval is, and this will in all likelihood only happen in private companies. Let's say Daniela, Roche, Ayla, and Usia are our shareholders, and Usia wants to exit the company. He wants to go and travel around the world or go and live on the farm permanently. So he wants to sell his shares. None of the other shareholders are in a financial position to buy his shares from him, but they don't want him to sell his shares to a random stranger because they want to keep the company more private. So the company can then decide to buy back Usia's shares. So that is a specific approval to buy back a specific quantity or amount of shares of a specific shareholder. Now, this is the first instance where you must base your answer on the facts. If I'm telling you the company wants to buy USIA's shares, don't write, there must be a special resolution which can be a general approval or a specific approval. You will not get maximum marks for that. Tell me there must be a special approval. This will be a specific approval for this transaction. Specify which one of the two it is. Once the special resolution has been adopted, the process can start. Next requirement is then that an offering circular must be sent to all the affected shareholders. So if it's 50% of the preference shareholders, then an offering circular must be sent to all the preference shareholders so that they are all informed and can decide, do they want to make use of this offer or not? Do they want to offer their shares or not? The offering circular is not required if, as part of this resolution approving the transaction, it was agreed not that an offering circular is not required. This will only happen if it is a specific approval for a particular acquisition. If it's a general approval, there will never be a provision in the special resolution that no offering circular has to be sent. But obviously, if it's a specific approval, then they don't need to send the offer to the other shareholders because they can't sell their shares. This is only about UCL shares. So once again, tailor your answer accordingly. Don't tell me there must be an offering circular, but it's not required if agreed in the special resolution. It's also not required if the company is listed on the Namibia Stock Exchange. If it's a private company, you're not going to tell me as part of your answer that it's not required if the company is listed on the stock exchange. Because it's a private company, it won't be listed on the stock exchange. Tailor your question, be specific which of these requirements you refer to. Once the offer has been sent, then the company can buy back its shares. The money to pay for these shares, the consideration, can be paid out of any of the reserves of the company. The company can actually even go and borrow the money to pay the consideration for the shares. This is the point where I must remind you, when we did redemption of preference shares, I warned you at the time, when you're talking about redemption of preference shares, don't, although the terminology, the English language means the same, but talk about redemption of preference shares because it's a different procedure from the company buying back its own shares. That's what we're doing now. Redemption of preference shares is one of the big differences. Redemption of preference shares may only be paid out of income derived from a fresh issue of shares or from profits available for dividends. Whereas Section 89, buyback of shares, consideration can be paid out of any reserves. Once these shares have been acquired, they are cancelled and they then become authorized but unissued shares. So the memorandum of the company, where you get your details of your authorized share capital, that remains the same. They remain authorized, but your balance sheet will differ because now they will be unissued shares. They're authorized but unissued. And that will lead then to a reduction of the share capital of the company. The old system, common law system, capital maintenance, a company was never allowed to reduce its share capital unless it was in the ordinary course of business. Buying back of shares leads to a reduction of share capital. Buying back of shares, a company may not buy back all its shares, obviously, because then there are no shareholders, your company cannot exist. The buyback can also not result in the remaining shares only being redeemable preference shares. Go back to when we did capital of a company, different classes of shares. You already learnt that a company may not have only preference shareholders. There must always be some ordinary shareholders. This is just reinforcing and adding on to that. Buyback of shares may not have the result that there are no ordinary shares left, may not result in only redeemable preference shares being remaining. Okay, this slide is just a reminder to what I've been stressing in the previous slide. If you're setting out, explaining the procedure to be followed in your exam, refer to the appropriate procedure. Is it a general approval? Is it a specific approval, etc., etc.? Now, capital maintenance rules were originally crafted or came into existence to protect your creditors. But I've pointed out to you that the newer way of thinking, the more modern way of thinking, is that it's not only creditors that must be protected, but also your shareholders. How does Section 89 address this? Creditors are protected by the provision that at the time of the acquisition, the company must be both liquid and solvent. You are accounting students, I don't need to explain to you what liquid means and what solvent means. Liquid, they must be able to pay their debts in the ordinary course of business. Solvent, their assets must exceed the liabilities. If it is subsequently found that at the time of the acquisition, when this money was paid out, the company was not liquid or solvent, the shareholders whose shares were bought can be called upon to return the money that they received. They return the money, their shares will be reissued to them. So they don't have to return the money and be left with nothing. Their shares are then reissued to them. If the money cannot be recovered from the shareholders, the directors can be held jointly and severally liable for any acquisition, any amount paid out for the acquisition of shares. So here we have another example of statutory piercing of the corporate veil, because the decision to buy back the shares would have come from the directors. They were supposed to check, how is this going to influence the company? Will the company still be liquid? Will it still be solvent? If they didn't do their job, they are punished, can be punished by having to pay back the amount out of their own pockets. But it's not only creditors that are protected, shareholders are also protected. How are the shareholders protected? Firstly, because the transaction has to be approved by shareholders by way of a special resolution. And secondly, if it's a general approval, they are also protected by way of the offering circular that must be sent, so that everybody has an equal opportunity to participate in this buyback or not. Any questions about that?
No questions, ma'am.
No questions. Okay, let's carry on then. So our second capital maintenance rule, if I can just go back to them quickly, was that a company may not pay dividends out of capital. This has also since been changed. Section 96 of the Companies Act now provides, this is also a new provision in the 2004 Act, that a company may pay dividends out of capital. Company may now pay dividends out of any source, out of any source of money. 3 requirements there. The articles must permit the payment of dividends. That is a general provision. You will find that in all companies except for your Section 21 companies, that dividends may be paid. And then at the time of paying the dividends, the company must also pass the solvency and liquidity test. No provision, no requirement for the payment of dividends that it must be approved by a special resolution. You don't really have to protect your shareholders when it comes to the payment of dividends, because they are literally the people that are benefiting, they are receiving the dividends. So no special resolution required. It is a managerial decision whether the directors are going to declare dividends or not. Then related to this particular provision, remember we're dealing now with a common law rule that a company may not pay dividends out of capital. There's another section in the Companies Act, namely Section 85, which deals with this. Section 85 is still in the Companies Act, which is why we are still finding out why I'm still teaching it. In real life, in practice, it's not really used anymore because Section 96 has sort of superseded it, and Section 96 is an easier provision. But Section 85, this is an old provision. It was already in the previous Companies Act. There was a provision that stated that dealt with the payment of interest on shares out of share capital. So to use the word interest as opposed to dividends. This provision was brought into the Companies Act, the previous Companies Act, because sometimes it takes a long time for a business to start making money. And then people were reluctant to buy shares in this company because it would take a couple of years before they would be receiving dividends, before they would be seeing any return on their investment. So to make it more appealing, Section 85 of the Companies Act provided that in certain limited circumstances, a company was allowed to pay interest on shares out of their share capital. This was limited to instances where the shares were issued to finance construction work or the acquisition of plant, machinery. So finance construction work takes a couple of years to build a building. It's going to take a couple of years for the business to start generating any income. So if the shares were issued to finance construction work or the acquisition of plant, the company was permitted to pay interest on share capital to the individual shareholders. This payment of interest had to be authorized by the articles of the company, as well as by a special resolution of the shareholders. And in addition, the approval of the Minister of Trade and Industry was required. Interest on share capital may not exceed the rate of 10% per annum. So it's a more arduous process to get the permission, because you also need permission from the minister, the approval of the Minister of Trade and Industry. And you would obviously have, before he's going to give his approval, the company would have to convince him that this would not paying interest on the out of capital on the share capital would not detrimentally affect the creditors of the company. So Section 85 is still in the law, it's still on the books, but it's rarely used in practice these days. Section 96 is a lot easier to use. Our third capital maintenance rule: a company may not issue par value shares at a discount. This was also changed already some years ago, already in the previous act. This is not a 2004 amendment, because it was found already that the strict rule that a company may not issue par value shares at a discount was detrimental to the company, in the sense that they might not be able to share or to sell their shares. It's the same as any shop. At the end of the winter, they start selling their winter clothes at a discount, so that at least they get them sold, they get some money in. Similar provision, similar underlying thought process behind this. Company may actually issue shares at a discount, provided that the following requirements are met. It must be of a class already issued by the company. So if the company has Class A shares at a par value of $200 per share, and they haven't issued a single Class A share, then Section 87 won't come into play. Then they can actually just change the articles and reduce the par value of the shares. But if shares have already been issued, they cannot retrospectively reduce the par value. So they have to use Section 87, must be of a class already issued by the company. It can only happen at least 1 year after the company has become entitled to commence business, or the date of the first issue of that class of shares. So some time must have passed so that the company can be sure that nobody is buying these shares at the par value. It must be approved by a special resolution specifying the maximum rate of discount, and then sanctioned by the court. So once the shareholders have adopted the special resolution, the company must apply to the High Court of Namibia for approval. They will once again have to convince the court that this will not jeopardize the interests of the creditors. And these shares must then be issued within 1 month of the court order, failing which the order will lapse and they have to start the whole process over again. Questions? Everybody still with me? Alicia, are you with me? Evelina, thank you.
Yes, ma'am.
Wonderful. Okay, we're going faster than I thought we were. We're making good progress. There's one more left. Our statutory rule: no financial assistance for the purchase of its own shares. terms of the previous legislation, a company, say this is Section 44 of the Companies Act, a company is prohibited from giving, whether directly or indirectly, or whether by means of a loan, guarantee, provision of security, or otherwise, any financial assistance for the purpose of or in connection with a purchase or subscription made or to be made by a person or for any shares in the company. Lots of words, essentially saying that if you buy shares, you have to pay for them yourself. The company may not give you financial assistance to buy shares in that company. In any manner, whether they lend you the money or whether they just give a guarantee or a suretyship to the bank or anything. This was very, very strictly applied, to the extent that there were some court cases where even if somebody sold something, let's say, who do we have here? Let's say Avelina sold a car to a company, and then shortly after she sold the car, she bought shares in the company. There were transactions like that that were set aside. That was seen, the company buying the car from her was seen as giving her financial assistance, enabling her to buy shares in the company. And that was illegal, and the transaction was set aside. Now you can think that this was more impractical than it actually benefited the company. So in due course, already in the older legislation, some changes were made to this provision, to Section 44. The way that they did it at the time is, instead of changing the section and saying a company may give financial assistance, they kept it in the negative, but brought in certain exceptions. First exception to the general rule was that financial assistance in the ordinary course of business by a company whose main business is lending money was exempted from this prohibition. The strict application of the rule was that if Alicia had a bank account at Bank Windhoek and she wanted to buy shares in Bank Windhoek, she could not borrow money, take an overdraft from Bank Windhoek to buy shares in Bank Windhoek. It would have been stupid in any event. You don't borrow money at a high interest rate to buy shares, but be that as it may, if she was a client of Bank Windhoek, she could not borrow money from Bank Windhoek to buy shares in Bank Windhoek. She would have to go and open a new account at Standard Bank to buy shares in Bank Windhoek. You can see that this was just silly, so that was the first exception that was made. That if the company is literally in the business of lending money, it's not forbidden in terms of this particular section. The next two bullet points, the next two exceptions that were made, basically go hand in hand. Also exempted from the prohibition was shares to be held by trustees for the benefit of employees, or loans to employees to obtain shares in the company on their behalf. These relate to companies sometimes have, at the lack of a better word, social upliftment schemes, where if employees have worked for them for a certain number of years, they can buy shares in the company. So then they've been a loyal employee for many, many years. Now they become a shareholder, so they're a part owner, gives them a bit of a sense of pride, that type of thing. The sad irony behind this is very often these employees who could now participate in the scheme couldn't actually afford to buy these shares. Like Mema Jakubina has been the cleaner and the tea lady for 30 years, very loyal employee. Now she gets the opportunity to become a shareholder. But in the meantime, she has raised her own children and her children's children and her children's children's children. She can't afford to buy these shares. So this whole upliftment scheme is actually pointless. So companies, to be able to actually make these lower grade employees, put them in a position to make use of these upliftment schemes, companies were allowed to assist them financially to acquire these schemes. So those are the old exceptions. The 2004 Act brought in a further exception, which is the one that's printed there in bold, that Companies Act now states that a company may not give financial assistance for the purchase of its own shares unless that transaction has been approved by way of a special resolution and the company is both solvent and liquid. So this is in fact similar to what we looked at over here. The buyback of shares, special resolution, solvent and liquid. Instead of replacing the whole Section 44 and just saying, like it does with Section 89, Section 89 says a company may buy back its own shares if it meets the following requirements. They could have also said a company may give financial assistance for the purchase of its own shares if it meets the following requirements. People who wrote the Act decided to make it unnecessarily complicated, and instead of changing the section, to keep the section and just include another exception that financial assistance may be given, provided that there is prior approval of the particular transaction by way of a special resolution and the company is both solvent and liquid. The Act is very specific and still fairly strict about this. It must be a prior approval for the particular transaction. So you cannot adopt a special resolution saying that the company will always give financial assistance. There must be a prior approval. The company will give financial assistance to Alicia. If there's no prior specific special resolution, the transaction will be void. Creditors are protected by way of the solvency and liquidity tests. Here, this section differs from 89. It doesn't refer to joint and several liability of directors. It actually criminalizes it. They can be liable for a fine of up to $4,000 or imprisonment of up to 1 year. Shareholders are protected by the special resolution requirement and the fact that it must be a prior approval for a particular transaction, so no general open-ended approval. That's it. This actually went a lot faster than I thought it would. Are you everybody with me? That was very bad English for me. Are you everybody with me? That's bad English. Is everybody with me? That's better. Do you keep up? Thank you, Evelina, Yusia, Daniela, Alicia. Great, wonderful. So we don't have to have an extra class on Saturday. We are on track, Miss Ayla. Have a lovely evening, the rest of you. Sleep well.
Thank you, ma'am. Same to you.
Miss,
Yes, Alicia.
excuse me, ma'am. Before you go.
Sorry?
Excuse me. Before you go, ma'am.
I'm still here.
How's the test results coming for test 1?
From very good to very bad.
Very good and very bad.
But you're fine, Alicia.
When are we going to get the results, ma'am?
They will definitely be entered on published on the kiosk in the course of the weekend.
Oh, in the course of the weekend.
Yes.
And then for next week we will be preparing for test 2.
What is do we have a revision class next week? No, I don't think we have a revision class. Yeah, test 2
How
is
about something practical?
Test 2 is online, so it's open book.
Yes, ma'am.
Let me quickly just check your course schedule here. So I don't want to. Just give me a second. I just don't want to fall behind. Where is your course schedule? There it is. Let me open it quickly. I don't want to fall behind with the work.
Yes.
Okay, for next week we have to 15, and unit 15 is included in the test. So we will do unit 15. Okay, let's decide this. Let's do it this way around, because unit 15 is quite long. Let's in event, and for those of you that can't attend, as you know, the class, I record my classes. Let's work in any event, a short class, maybe just 3/4 of an hour on Saturday late morning. Then we start with unit 15, and on Tuesday we finish unit 15, which then leaves us with Thursday for a revision class. Would that work for you? Yes. So let's do that. Yeah, we have a short class on. Sorry, I can't
squeeze in something practical.
So you're asking me to open a practice quiz for the quiz you're going to do on Saturday.
In the good name, in the good name of everything.
Yeah, I'm not making promises, but I'll see what I can do.
Awesome.
I'm sure I can figure something out. Let's start with then on Saturday morning, say 11 o'clock. We have just a short class so that I can get sort of halfway in the unit on unit 15, which we can then finish then at time, a reasonable pace on Tuesday, so we don't have to rush. And Thursday will then be spent on a revision. Oh yes, as a revision class.
Okay. Which chapter is unit 15?
Unit 15 is
groupings or auditing?
No. Unit 15 is external auditors.
External auditors, okay.
Yes.
All right.
Okay, so we'll do it like that. I think that will be the best way to benefit all of you. Okay, have a lovely evening further. Thanks for joining.
Good night.
Bye.